All right, welcome to Chapter 2. Again, we're completing our journey through the Court Procedure and Evidence class here at Wake Tech Community College. We're using the textbook Criminal Procedure by Joel Samara. I believe this is the 10th edition, and we are now moving on to Chapter 2, which is criminal procedures and the U.S. Constitution. So we're going to talk a lot about the Constitution, obviously, in this lecture. There's going to be some supplemental material, and obviously there's going to be a few changes if you're just following the text along, but we'll try to keep this lecture in at about an hour, maybe a little bit more. All right, so first of all, your book starts talking about constitutionalism, which is a big long word, but basically it says, at least in a constitutional democracy, which is what America is, constitutionalism is the idea that the constitutions adopted by the whole people are the higher law of the country. More important than what the legislature does. Now, of course, America, we have a federalist system, which means we have the federal legislature, which is Congress, the Senate of the United States, and the House of Representatives of the United States. And then each state has two legislatures typically. I believe there was a unicameral legislature for a while. There was one, but I think they went back to two. But for example, we're here in North Carolina. North Carolina has the North Carolina House and the North Carolina Senate. There are two constitutions that affect us here in North Carolina directly. There is obviously the federal constitution, and then there is the state constitution. The constitutional law is higher than the law that is passed by those legislatures. It is more important, and if there's a conflict between what the legislative law says or an executive order by either the governor of the state or the president of the United States, if they are in conflict with the Constitution, they lose and the Constitution wins. The Constitution is the highest authority in criminal procedure. It trumps all other laws that are passed by general legislatures like North Carolina or the federal congressional Senate and House. Oops, went backwards there, sorry. Now, there are arguments for and against having a strong constitution. We have a very strong veneration of our Constitution. Some scholars studying Americans' attitudes towards the Constitution says it's essentially a civil or civic religion. And once you start having a religion, belief can become more important than any contradictory fact that's introduced. So we have to be a little bit careful. So what are the pros for their constitutional system? Well, first of all, it creates a very strong legal environment. It should provide for great stability because constitutions are difficult to change and amend. They are usually shorter. The United States Constitution is very short. So you can kind of grasp the whole thing. It enables individuals and groups to understand what rights they have and what responsibilities they have. And it recognizes some rights and provides protection for the exercise of those rights. Now, the cons here are that since the Constitution is so difficult to change and is imposed from our system, from our perspective, from the top down, we elect officials, but they write the Constitution, or they wrote the Constitution, or they write constitutional amendments, and that it's imposed on us, that you can have their beliefs become more important than the general attitude of the society, which is not necessarily a bad thing. I mean, the society might believe something crazy or bad. Another con is, and this was a debate that kind of went on even in 1787 when the first Constitution was adopted, and people said, well, if you give a Bill of Rights, if you say, here are your rights, 1 through 10, which was the Bill of Rights, then some people are going to say, well, that's all the rights you have. So, and this goes with the second one, only protects those rights that are defined. If you say, here are your rights, what about if there is something else that's not mentioned? And let me give a quick example. One of the contentious issues that rocked the United States for a while was gay marriage. So the question was, it's not in the Constitution. There's nothing in the Constitution that talks about marriage. However, there is things in the Constitution that talk about due process. And the question becomes, is the right of marriage a due process right, since due process is not defined in the Constitution? And we're going to hear more about this. Well, if you interpret a Constitution in a strict way, strict constructionalist, you'd say, well, no, it's not in there, therefore you don't have that right. States can take it away, or the states can give it. So the con of a strong Constitution is it in theory, can only protect those rights that are defined unless you read the Constitution in a very elastic or open way, in which case, how important does the Constitution become? Okay. Constitutions have 6 basic characteristics according to your text. First of all, they're the highest form of law. That's kind of self-explanatory. They express the will of the whole people, remembering, as a slight caveat, that will is expressed through our elected representatives. They always bind the government through interpretation. That's true. They cannot be changed by the government. Now, that's not necessarily true. Obviously, the first 10 amendments, by that very name, amendments, are changes to the Constitution. And these were enacted by the government, by the people, through the government. They can only be changed by direct action by the whole people. Well, that's simply not that true, because the Constitution can be changed a couple ways if you look at the American Constitution. But the primary way it's changed is through amendment. So what happens is a amendment passes through the Congress of the United States. I don't believe it has to be signed by the President. I'm pretty sure it does not. After it's passed by the House and the Senate, it goes to the states and has to be ratified by a supermajority of the states. It embodies the fundamental values of the people, and that's true to some extent. I think it's a true statement. Okay, I'm going to have a bit of a diversion here. It's not in your text. We're going to give you a very, very brief history of the Constitution, so that as we talk about it, I think some things will become a little clearer. Now, obviously, if you take our class on constitutional law, there'll be a little bit more about this, but here's a quick 5-10 minute breakdown of what happened. Now, starting with the idea that if the Constitution is fundamental to us understanding evidence and procedure, then we got to know a little bit about its history. The basic Constitution that replaced the old Articles of Confederation was drafted in Philadelphia in 1787. So we're looking at 130 plus years ago. And it was drafted just less than about 5 years after the American Revolution really ends. It has been amended or changed just 28 times, and the first 10 of those were almost immediate. That's the first Bill of Rights. So if you think of the roughly 200 odd years since its adoption and the Bill of Rights, there's just been 18 changes, which means there's been roughly a change every 10 years. And some of these changes are pretty minor. Some of them are pretty major. Only a few of them impact us in court evidence and procedure. So who created it? Now, one of the things you're going to hear, and I think we can take a brief diversion and talk about this, is the people who wrote the Constitution were white, they were men, they were Protestants, and they were the elite of each colony. But I want to emphasize this, I do not want you to think that just because they were men that they completely ignored women, or that they were white that they only had whites' interest involved, or that they were Protestant they only had Protestants. Just because you were a member of a group doesn't mean that everybody in that group shares the same goal. Obviously, people can have different perspectives, and when I say elite, some of the people, for example, in the Constitutional Convention were quite wealthy. Some were not. Some were engaged. They were wealthy because they engaged in manufacturing or shipping. That would be the New Englanders usually. Some of them were wealthy because they owned slaves, like the Southerners, like Pinckney and the rest. Some of them had gone through the American Revolution and served just in the state government, so they had one perspective. Some had served in the army, so they might have a different one. So when it was drafted, so we talked about the who. We've got these people sitting in Philadelphia. when it was drafted, we're only about 5+ years out of the American Revolution. And this is a very unstable time in America. There's major problems on the frontiers. There's problems getting the English to really accept the treaty ending, the Treaty of Paris, which ended the American Revolution, the war. So they haven't evacuated some stuff. There's threats from people around it. There's monetary threats. There's internal threats, like there's some rebellion, Shays Rebellion, and a few others. There's some real problems. So you do have to remember that these people, these white men, these white Protestant men, are creatures of their time. They're writing this when there's all these problems. So the why, which is the next thing, is they were created it was created really to fix problems that they saw earlier in the Articles of Confederation, but also to deal with current problems as they existed. And as much as the American Constitution is a masterpiece and is one of the most important documents ever written by human beings, let's not believe that they're demigods. Let's not say that these people that wrote it, and we're going to talk about some of the people that wrote it, were absolutely perfect. So we're going to talk a little bit on this next slide about who was there. So here's a listing of just 5 or 6 people who were there. Two pop out, the first and the last there. James Madison, who's sometimes called the author of the Constitution, and George Washington, who was a delegate from Virginia, later president. There were at least 2 people in the room that were president. Now, part of the problem when we talk about the drafting of the Constitution is we don't have minute-by-minute records of this is what this person said, this is what that person said, this is what they wanted, this is what... We have diaries, we have some accounts, we have things that we know were argued about, like the Virginia plan, the New Jersey plan. You're going to have a representative, or is it going to be based on states? But we don't have a perfect transcript. We don't know everything going on. Here are some of the other people that were there. Of course, Alexander Hamilton, had to throw him in since Hamilton is such a popular topic right now. He was the delegate from New York. He favored a stronger government. So did Madison, to many extents. Benjamin Franklin, of course, I threw him in, the scribe or the scholar of Pennsylvania. Quite old by now. He's in his 80s, which is ancient by standards of the 18th century, the 1700s. I threw in William Blount. He was the delegate from North Carolina. I threw in Roger Sherman because he's a really interesting character. I believe, if I'm not mistaken, that Roger Sherman's one of the few ones that was present at the Declaration of Independence in 1776, the drafting of the Articles of Confederation, and the Constitution. So he was there the whole time. Now, Roger Sherman, I'm not positive, but I believe he was not a particularly wealthy person. He ran a shop, I think it was a cobbler shop, in Connecticut. And of course, then you got George Washington, arguably the most famous person there. And it was interesting that Washington was there because, of course, when they were getting around to drafting and creating, well, this is what the executive is going to be like, this is what the president's rights are going to be, everybody pretty much knew that George Washington was going to be the first president. So they kind of framed it saying, well, we'll make him commander-in-chief because, after all, Washington's going to be the first one. He was commander-in-chief. All right. For ratification, there were people that opposed ratification. These were called the Anti-Federalists. And then the people who supported ratification were called the Federalists. Now, if you want to read more about this, let me recommend there was a series of writings written by Madison, Alexander Hamilton, and John Jay, and they are a compilation of these short articles, really, that were published primarily in New York, but elsewhere. They're called the Federalist Papers, from which we get, obviously, this becomes the name, the Federalists, the people that supported the Constitution. But there was opposition to the Constitution. So in order to get it ratified, it was more popular in the North than in the South. The South was a little bit afraid that it was giving too much power to the central government. So in order to convince the people in the South to vote for it, and to some extent in the middle colonies, Pennsylvania, New York, New Jersey, there had to be a promise made that a Bill of Rights, a restriction on the federal government, would be passed. These first 10 amendments that were adopted, and there were more than 10 proposed, but the first 10 amendments. So these were added to the Constitution almost immediately, and these have a big impact on evidence. We're going to talk about these bills of rights, the Bill of Rights, specific constitutional amendments here. They have a big impact on how evidence is used in court and what procedures are permissible. Okay, so let's jump in and talk about procedures. The U.S. Constitution is, as we said, the highest law in the land. So you've got the Constitution, then you've got the individual laws of the state. And in the Chapter 1, I showed you North Carolina has rules of evidence. North Carolina has rules of procedure. Well, if those rules of evidence or procedure conflict with the U.S. Constitution, they lose. So the law of criminal procedure is based upon the bedrock of the Bill of Rights. You've got to follow certain rules, like detecting and investigating crimes, apprehending suspects, prosecuting and convicting defendants, and punishing criminals. And we say you have to follow the rules. You can't break something like you have the right against self-incrimination, Fifth Amendment in the Constitution of the United States. A state couldn't pass a law that said, no, you have to testify. Equally important are the rules generated by SCOTUS, which is the Supreme Court of the United States. So a lot of these standard rules that we briefly mentioned, and I showed you a picture of in Chapter 1, the rules of evidence, the rules of procedure, some of those are actually drafted, created, supported by, I guess is a better word than drafted, by the Supreme Court of the United States. But even if they didn't directly draft a rule, they very often would hand down a Supreme Court case that said this is how the Bill of Rights, this is how, using the Fifth Amendment as our example, this is how the Fifth Amendment applies. So the Supreme Court, that's what SCOTUS means, Supreme Court of the United States. SCOTUS is very important because the Bill of Rights is a few sentences, right? Each one of the amendments is a sentence or two. And what that means has to be interpreted, and the people that interpret it are the Supreme Court of the United States. All right, most of the criminal procedures that we're going to talk about that are in the Constitution are really found in just 5 amendments to the Constitution, 4 of which are part of the Bill of Rights, and the 5th of which kind of repeats a little bit of what's in the 5th, but also changes a few things. So that's going to be the 4th Amendment of the Constitution of the United States, the 5th Amendment of the Constitution of the United States, the 6th Amendment of the Constitution of the United States, the 8th Amendment, and the 14th. So let's jump in and briefly look at them. So the 4th Amendment of the United States says basically the right of the people to be secure in their homes against unreasonable searches and seizures. The 4th Amendment has a lot to do with searches, which are basically going to be search warrants, and seizures, which is basically going to be arrest. And the important thing is neither an arrest nor a search can be unreasonable. Now it only says that in the abstract. It doesn't tell us what unreasonable is. The one thing it does add is it says if you're going to have an arrest or you're going to have a search, you have to have probable cause behind it. You simply can't have a search because I want to have a search. I want to search through your records to look for crimes. What our Constitution says is you can't go on a fishing expedition like this. You've got to have an actual deep suspicion. You've got to have what we call probable cause, which is not defined in the Constitution. It takes generations to define what sufficient probable cause is in order to conduct a search. Now, the 5th Amendment I mentioned before. The 4th Amendment is usually called the Search and Seizure Amendment. The 5th Amendment is usually called the right against self-incrimination, although there's more there. So what are the 4 basic parts of the 5th Amendment that impact us in evidence and procedure? Well, a right to a grand jury in federal cases. So some states don't use grand juries very much. Some states use them a lot. North Carolina, for example, almost never uses grand juries. We do have a grand jury system. It's not used. It can be used for drugs. There's a few parts where there was the war on drugs, and we kind of shook it up a little bit. But we don't use the grand jury very much in state cases. It's still used in federal cases quite a bit. The right against double jeopardy, which essentially says, and I'll paraphrase what the Fifth Amendment says, is I can't try you twice for the same crime. Now, when we say the same crime there, it's not like if you got pulled for speeding on November 1st for doing 65 and a 45 on the Beltline, and you got pulled on December 1st, a month later, for doing 65 and a 45 in the same location, doesn't mean we can't have two trials. We just can't try you twice for the first one if you're found not guilty. That's what double jeopardy is. The right of due process. Now, this is really the first time due process raises its head, and we're going to distinguish later between procedural due process and substantive due process. But suffice it to say that due process, at a very crude shorthand, which only gets you a little bit into it, is however you're going to do things has to be fair. And finally, your right against self-incrimination. You can't be compelled to testify against yourself. Now, the Sixth Amendment, the third of the big five, sometimes called the trial rights amendments. First of all, it grants you the right to a speedy trial. But, big asterisk here, it doesn't tell you what that means. Is it after you're arrested, you have a right to go to trial in 48 hours, 72 hours, a month, 6 months? The right to a public trial. Now that's much more easily defined. We can't have secret trials. We can have secret courts. So this is an interesting thing. If you think about this, if I'm going to get a search warrant to look for evidence that you have something illegal, do you have the right to know, hey, we're coming to your house now to look for something in your house? You have the right to be present in the court for a search warrant? And the answer is no, you don't. You don't have the right. Because it's not really a trial, it's before the trial. Now sometimes that gets a little dicey, and sometimes it gets a little uncomfortable for civil libertarians. For example, we have a court called the FISA court, which is Foreign Intelligence Service Act court, which is a secret court. You don't even know the judges. You don't even get to see the records of the court, and they can issue search warrants. So the government is always kind of pushing that a little bit. You have the right to an impartial jury, and this is something that was fought over for years. I mean, what's the jury got to be like? Sometimes you'll hear the term jury of your peers. Does that mean it has to be people that look like you? If you are a 85-year-old Buddhist from Bolivia, right, and you're a woman, you're an 85-year-old woman Buddhist from Bolivia, BBB, Buddhist from Bolivia, does your jury look like you? Does it all have to be women? Do they all have to be Buddhist? Do they all have to be from Bolivia? And the answer is no, but it has to be impartial. One of the things that tends to make juries impartial, and we're going to see some fights about this, is when they look nothing like the defendant, or when they're composed of groups that are hostile to whatever groups the defendant belongs to. You have a right to a jury made up of persons from the state and the district where your crime was committed. Kind of keeps things local there. You have a right to be informed of the charges against you. So, in the bad old days of the Inquisition, people would be arrested, they'd be brought in, they'd say, okay, you committed a crime, how do you want to plead? And you're thinking to yourself, well, what crimes do they know about? Because people commit crimes all the time. You might speed on the way to class. You might not declare all your income on your taxes. So if you got arrested and they could say, well, you committed a crime, if you confess, it'll go easier. If you don't, it'll go harder. You're afraid, well, what do they know? You have the right to confront witnesses against you. This is sometimes called the subpoena right. Basically, if someone makes an accusation, you get to cross-examine them. And if you don't get to cross-examine them, the subpoena is really next, this is a confrontational clause, you can't find the truth, because anybody can tell a good lie. But when you can question someone that's telling a lie, then you often can get much, much closer to the truth. You have a right to compulsory process to obtain witnesses. In other words, you can subpoena people and bring them into trial. you have the right to a defense counsel. Now, initially that just meant if you had the money, you could hire a defense counsel. Later, it's going to mean something different, and that's going to take a Supreme Court interpretation. All right, so we got two more amendments to go, the 8th and the 14th. The 8th kind of is the punishment, and it says we can't require excessive bail. Well, excessive bail when? And what is excessive? And, bail is you've been accused of a crime, there's been probable cause you committed a crime, you've been arrested, but we haven't had our trial yet. Do you sit in jail? We use jail to punish people, so you're telling me that you can punish someone who's not been convicted of a crime. The counter-argument is, yeah, but you might arrest someone who's dangerous or who might not show up for trial and flee, so we need to hold them. So the way we guarantee you show up is we say, well, to make sure you show up, you have to post bail. What happens if we won't grant bail? Or if bail is so high that no one can pay it? That really goes to excessive bail. Then there's excessive fines. What do I mean by excessive? Well, if you earn $10,000 a year, $100 is one thing. If you earn $100,000 a year, $100 fine is a lot less. If you earn $100 million a year, $100 fine is nothing. So does that matter? What is an excessive fine? Does it matter from the individual's point of view or from the greater society's? And of course you have a right against cruel and unusual punishment. One of those phrases strung together that is not defined. What is cruel? And some people will argue that solitary confinement is cruel, or the death penalty is cruel. We'll talk more about that. The final one, and this is part of what's sometimes called the Civil War Amendments. Civil War Amendments obviously took place after the Civil War, just during it. That's the 13th Amendment, which is abolishing slavery, the 14th and the 15th. So we call those three the Civil War Amendments. But the 14th Amendment really harkens back to the 5th Amendment. It gives you the right of due process of law in state criminal proceedings and the right of equal protection of the law in state criminal proceedings. Because what we were a little bit afraid of, and when I mean we, I mean the people that won the Civil War, the Americans, as opposed to people that tried to break the country up, the Confederates. The Americans were afraid that the ex-Confederates would abuse the recently freed population, that they wouldn't give them a fair trial, if there was a trial, or they wouldn't give them equal protection. So they said, you've got to give people in your state courts equal protection. This was very contentious because really for the first time the federal government is reaching into the states where almost all the criminal law is practiced. 90+% of criminal trials are at the state level, not at the federal level, and just starting to say, you got to follow certain rules. All right, the U.S. Constitution and the courts. There is a clause in the Constitution. The Constitution itself, not the Bill of Rights, is broken up into three major components. Article 1 establishes the legislative branch. Article 2 establishes the executive branch of the presidency. So we've got the Senate and the House set up in 1. We got the president set up in 2 along with his cabinet. Then we got the courts set up in 3. Now the courts establish the Supreme Court of the United States. There's an Article 4, there's how we amend the Constitution, then we got the Bill of Rights and a few other things. But one of the parts of the Constitution, not in the Bill of Rights, is what's called the Supremacy Clause. And it says that if there is a conflict between federal law, which has been validly drafted and enacted, and state law, federal law wins. So as long as the feds are following the rules, right, they can't enact anything that's unconstitutional, for example. Then if a federal law is different than a state law, feds win. The other part of this is judicial review, and that's the power of the Supreme Court to declare a law unconstitutional. We'll talk more about that in a little bit later slides. Together, these establish that whatever criminal procedures adopted in a court, whether you use grand juries like North Carolina doesn't, or you use them like California does, you are still answerable to the Supreme Court of the United States. And if the Supreme Court of the United States makes a ruling that says, let's take a classic evidentiary rule, Miranda rule, says you have to inform people of their constitutional rights. That's Escobedo and Miranda. And usually when I'm throwing out proper nouns, proper names, I'm referring to a specific case like Miranda v. Arizona, or famous cases you might have heard like Roe v. Wade. I'll call that the Roe case. Usually you use one, sometimes you use two. State rules cannot violate the U.S. Constitution. Now this raises some of the first bad Latin we're going to learn in here. Precedent and this term, S-T-A-R-E-D-E-C-I-S-I-S. Now that's Latin. Stare decisis is how it's traditionally pronounced, but if I have any Latin scholars in here, you're probably aware that the C sound that we use is usually a K in Latin. So you can argue that this is stare decisis, but we call it stare decisis. Stare decisis simply means let the decision stand, or precedent. So prior decisions of a court are called precedents. If 50 years ago, in the Miranda case, the Supreme Court of the United States said you have to read people their constitutional rights when they're under arrest and you're about to question them, then that is precedent, and you've got to follow that precedent, and the precedent stands. Now, sometimes, rarely, you can break or overturn precedent, but firmly entrenched doctrines are called stare decisis, and judges have to follow them. They're really not free to break them. They can try, but they'll get slapped down unless there's a real movement to change the law. The state courts are the source of criminal procedure, and they can be really important. First of all, there might be rules that the Supreme Court of the United States hasn't addressed yet. So, one of the questions might be in criminal procedure, can I admit someone's Twitters against them, their tweets? But the Supreme Court of the United States may not have a case that says yes you can, no you can't. So if the Supreme Court of the United States hasn't made a ruling, is that a violation of self-incrimination? For example, could a police department send a tweet to someone saying, were you the one that robbed the bank? And if they answered, is that a violation of due process if they were under arrest? So if it involves the United States Constitution and the Supreme Court hasn't decided yet, state courts can make rulings. Or if it doesn't involve the Supreme Court of the United States at all, there's no federal law, federal statute, constitutional issue, but it does involve their own state constitutions, then those courts can rule. Then they can make a decision. All right, the balancing test. Basically, one of the things we're going to look at is a balancing approach to stimulate judicial decisions making and academic writing to focus on two empirical questions. How effective are you in controlling crime, and how effective are you in impacting liberty? So if you're going to do something as a police officer, what's the impact on crime control, and what's the impact on freedom? And again, this is we started talking about this in chapter 1. This is that delicate balance. And sometimes you hear the Constitution as a delicate balance. This is that delicate balance between how much freedom do you want and how much security do you want. So if we come up with a new rule that says, and I'm making this up, the tweets of an individual are not admissible if a question was given by the police. Okay? Well, what effect is that going to have on crime control? Does that impact crime control? What is the individual effect on private liberty? If I say they are admissible, will you now tweet less and be less free? Are your tweets admissible against you? Let's suppose, here would be an example, and I don't think a lot of you will know the answer to this, and I don't think I'm going to tell you. But let's suppose that you keep a diary in private. You don't keep it electronically. You write out a diary at home. Dear diary, and you put down things you do. And maybe in that diary, you give information of something you did that you're not proud of, and it might be a crime, but this diary was just for you. Now, the police search your home and find this diary. And then they read that diary, and they want to admit what you said against you. They want to say, well, look, here is an admission of a crime from John Doe. And your counter-argument will be, well, you're making me be a witness against myself. So here's my question. What's the right answer here? What's the balance? Should that diary be admissible because it'll help us catch more people who commit crimes? Or is it an infringement on people's freedoms? Don't I have a right to communicate with myself, to keep my own private records? I mean, there is a constitutional requirement that says, the right of the people to be secure in their people's papers and home against unreasonable search and seizure says no probable cause, no warrants issued except on probable cause. And then it also says in the fifth, you're not required to be a witness against yourself. Well, isn't your writings a witness against yourself? So here is that balancing approach for you to look at. Next thing to talk about is the accuracy of determining guilt or innocence. The criminal justice system is operated by people. It's made up of people. We call it an institution, but there are witnesses to crimes. There are detectives that investigate the crime. There are suspects that might have committed the crime. There are lawyers, both prosecutors and judges. And defense attorneys. There are judges. There are jurors. These are all people. And we've got, these people's memories, their recognitions, their assessments, their inferences, social influence, decisions are all tied up with moral judgment and emotions and motivate the wheels of the system. They turn the wheels. This is what makes guilt or innocence. It's a messy process. They always tell you, you really don't want to know how laws are made or sausages. You really don't know. You might enjoy eating a sausage. You probably don't want to see how they're made. I often thought that if people had to watch animals being killed and then eat their flesh, there'd be fewer people who eat meat. But if you had to actually kill the animal yourself and then grind it up into a casing of its own skin, would you still be like, oh, I really want that bacon? You have to remember that any system we talk about is composed of people. And when you start drilling down on it, it can be unsettling. Because you can meet people in the system that are just, and we're going to meet one when we look at a couple of cases coming up, that are truly unpleasant individuals. And you say, wow, that's the judge? That's the prosecutor? Or that's the defense attorney? All right. You do have a dualistic nature of the Supreme Court. The will of the people refers to the power of the people to create laws, while the ancient concept of fundamental law places limits on that power. So, we recognize that the people have rights, but that there are limits on how these rights can be imposed upon. So, we hold these truths to be self-evident, that all men are created equal. We say that as a self-evident right. We don't say we get that right from the Supreme Court. We say that right exists. So the Supreme Court has to move between and understand the contradictory idea of, well, the people have the right to make their own laws versus, but there are some things out there that the people can't interfere with. Life, liberty, and the pursuit of happiness, or a fundamental constitutional right like your freedom of religion. So it is dualistic. So there are also state and federal constitutions, the federal constitution. Now, let's be a little honest. I'm sure I could quote part of the U.S. Constitution and you would recognize it. I could say, I could talk about the right of the people to be secure in their persons, papers, effects, or the right of the people to keep and bear arms. And you all would say, okay, the right of the people to bear arms, Second Amendment of the Constitution. The right against self-incrimination, Fifth Amendment of the Constitution. You'd be able to figure it out. But very few of us, and this includes almost all lawyers, even if we just focus in North Carolina, most lawyers that practice in North Carolina aren't that familiar with the state constitutions. Each state constitution gives people rights. I think the easiest way to think about this is that the federal constitution gives you the floor of your rights. You can't go below it. If the federal constitution says you have the right to subpoena witnesses, The state can't take it away. The state constitution is the ceiling of your rights. They can give you more rights that exist than under the federal constitution. So let's suppose you took a fictitious state, make up a state, Wyoming, right? The federal constitution might say, well, if you make a traffic stop, you then have probable cause to search. Okay, that's the floor of your constitutional rights. But the state constitution might say, for misdemeanor apprehensions or infractional apprehensions, which would be a traffic stop, there is no right to conduct a search. Okay, so there your federal constitution says you might have that right to conduct a search as the police, but your state's constitution is giving you more rights, so it can be higher. States can raise the standards, but they can't lower the standards. Okay, so we're going to look at a couple cases here. Actually, we're going to look at 3 cases, and I added a few slides to try to make these a little bit more interesting to you and a little bit more dynamic, we'll say. So the first case we're going to talk about comes from 1884, and it's a confusing case to read. Cataldo versus California, 1884. You have an individual who is arrested in California. Now, there's no grand jury here. And when he's arrested, he is really fast. I mean, it's so much faster than it is nowadays. He gets arrested, no grand jury. He gets arraigned, basically. He gets tried and sentenced just like that. And he appeals to the Supreme Court of the United States, and he says, look, the Supreme Court of the United States says if you're going to arrest someone, that it has to be based upon an indictment from a grand jury. So he argued that charging by what's called information, and this isn't information, this is a legal term of information, so don't confuse that, is unconstitutional under the 14th and 5th Amendments, and that refers to due process. The court said, no, not really. And they reject that idea. So if we look at that case, and here's the citation. It's 110 U.S. 516, 1884. This was a 7-1 vote. It really wasn't even close. You don't need grand juries to charge an information if you use an information to do it. It doesn't violate due process. And essentially what this says is states are free to construct their own laws without the infringement of the 14th Amendment. The grand jury is only absolutely required in federal cases. So feds still have to use grand juries. States don't. That's why North Carolina doesn't have to use them. And this remains valid law. You know, your book kind of curiously adopted this. It's really the beginning where the Supreme Court starts to look at something called incorporation. It doesn't get us too far. It's kind of a strange way to start. I wouldn't have started there, but your book has it, so you got to know it. All right. So I mentioned the Incorporation Doctrine. What is this? Well, the first thing to understand is, for the first 100-odd years of the Republic, or 80-odd years of the Republic, from 1787, when we have the Constitution, to 1864, when we have the Civil Rights, the 13th, 14th, and 15th Amendment, the Bill of Rights only applied to acts committed by the states. So you have the case of Barron versus Baltimore, which came down in 1883, which basically said, no, you know, if a state does something, the federal government isn't going to bail you out for freedom of press. Here, let me give you an example. During the period before the American Civil War, when there were abolitionists, the abolitionists would write newspapers and pamphlets, and they would send them through the U.S. mail. So they go to a state where there was, they go from a state where there was no slavery and there was opposition to slavery, like Massachusetts, and they would go to a state where there was slavery, and slavery was popularly supported by at least the slaveholders, like South Carolina. And in South Carolina, they would suppress the newspapers. They would seize them. Well, you might say, well, whoa. Federally, you've got freedom of the press, First Amendment, so they can't do this. Prior to incorporation, the answer is no, because the state of South Carolina can act. it can violate your right against self-incrimination. It can violate your right against freedom of the press, because it only applies if the federal government was going to suppress those newspapers. And you can see how this kind of throws that floor-ceiling analogy out the window. Basically what happens is your federal rights are there, but only apply if the federal government is acting. States can do what they want. But starting in 1890, and I'm not in love with starting with the Chicago, Burlington, and Quincy Railroad case, but your one does. I think it's a little bit better to start in 1925. But starting in the 1890s, or as late as 1925, the Supreme Court of the United States began changing this. They said, thanks to the 14th Amendment, your rights that are guaranteed in the Constitution have been incorporated in due process and now apply to state action. So in Gitlow versus New York, this is that 1925 case, they said, no, even though the conviction was upheld, there are rights that are guaranteed federally that apply to state action as well. All right, let's look at the next case. This is somewhat of a tragic case. It's a tough case. It's the Scottsboro Boys case. So the famous case is Powell versus Alabama. It came down in 1932. Of course, this is the height of Jim Crow. And there were 9 black defendants called the Scottsboro Boys who were charged with raping 2 white girls. It was an Alabama case. So, quick bit of facts about it. There were 2 groups riding a train. There was a group of whites, a group of blacks. And the black defendants and the whites got into a fight. They threw the white guys off the train. I think there's 7 of them they threw off the train, if I'm not mistaken. But 2 white women remained. And then there was an accusation that the white women were raped by the black men. They were arrested, and they got an alcoholic for a defense attorney. It was a court appointed. They were tried, convicted, and sentenced to death in 4 days. The Alabama Supreme Court upheld those convictions, so they were scheduled for execution, but it went up to the Supreme Court of the United States. So what happened when it went up to the Supreme Court of the United States? Well, this is really about due process of law. It says that you get some due process, and it really is only going to apply in the most egregious cases. And in this case, only in death penalty cases. It has a very limited impact. But what Powell versus Alabama says is, you've been guaranteed under the 14th Amendment due process of law. And that means you're going to have a reasonable time and opportunity to prepare for trial, to communicate with your defense attorney, and construct your case. And 4 days doesn't cut it. So they're going to overturn these convictions. Now, the problem, of course, here partially is these are 8 indigent defendants. They got no money. So what happens if you have someone with no money? How are they going to get due process? And it's really going to take another 30 years till Gideon v. Wainwright, which we'll talk about later, where we start to have court-appointed work. All right, the next slide is a picture of the Scottsboro Boys. You can see they're under, those guys behind them are the U.S. military. They might be National Guard, but the U.S. military. And the reason is they put them under guard because they were afraid that they were going to be lynched or beaten, whipped, killed, because this is the South in 1932. Not just the South, because lynchings and beatings and whippings occur across the United States, as far north as Minnesota, for example. Okay, so let's go to the third case your book talks about, and this is a very egregious case, Brown versus Mississippi. This is a couple years later. 3 black men were severely beaten until they confessed to killing a white man. There was a trial that lasted 1 day. All 3 were convicted. All 3 sentenced to death. The Mississippi Supreme Court looked at it and said, "Oh, it works for us. Go ahead, kill them." a little bit of a background about this case, the Brown versus Mississippi case. What happened was three sharecroppers were accused of going onto a white plantation owner's land, confronting him, and killing him. So the sheriffs went out, they arrested these three black guys, and during trial, evidence was admitted. I'll just read this. Defendants were made to lie or lean over chairs, and their backs were cut to pieces with leather straps with buckles on it. They were told they had to confess or the beatings would continue. It should be one defendant was strung up by the neck in a mock lynching until he confessed, and apparently you could see the swellings and bruisings around his necks. They were beaten, and they were convicted. There was some issue about why didn't they raise this sooner? Was there evidence of a fingerprint? Was that fingerprint manufactured and brought in? It's a little bit more complex than as black and white was like. But basically, the Supreme Court of the United States said, you can't torture people. Okay? Now, they bring the defendants back in. Remember, they've been sentenced to death. They said, okay, you're going to get a new trial. And they said, we're so afraid we're going to be convicted, we will plead nolo contendere. Nolo contendere means there's no contest. You have the evidence to convict me, even though I don't admit I did it. So they pled nolo contendere, and they got sentences ranging between, one of them got a sentence of just about 6 months, the other one I think got 3.5 or 4 years, and one of them got 7 years. Now remember I said that, don't forget that the people in the courtroom matter. Well, the state chief prosecutor, the one that was willing to tolerate whippings, beatings, lynchings, later became a U.S. senator, and he served for 42 years from Mississippi, never being defeated in his campaigns. Here's a picture of the three of them: Shields, Ellington, and Brown. Okay, so this all revolves around due process. When it should be there, and I will change these in post, when the 14th Amendment was adopted in the aftermath, it theoretically greatly expanded the powers of the government. But this expansion didn't take place till the 1960s. According to the Supreme Court of the United States, the 14th Amendment must provide due process and equal protection of the law. And procedural due process, how we do things, means it has to be fair. Due process guarantees fair proceedings for deciding the case. And if you don't get that, it's a violation of the Constitution. So we have what's called the Fundamental Fairness Doctrine. It basically provides a couple things. One, you have to be told what charges are against you. And two, you have to have a hearing on the facts before convicting and punishing defendants. Also, you can't torture people. Was a bit of a takeaway from this. All right, so let's go to the Incorporation Doctrine a little bit more. Remember, we talked about that once. By the 1960s, a majority of the Supreme Court has come to reject fundamental fairness, that previous doctrine, and instead start to favor what we started the discussion in these cases with, the Incorporation Doctrine. Forget about whether it's fundamentally fair. Let's just say that the 14th Amendment applies specific parts of the Bill of Rights to state criminal proceedings. Remember, we started off all the way back, which the Hidalgo case, where they said, no, you don't have these rights. Well, fast forward to the 1960s, and the courts are saying, yeah, we were wrong, or maybe more fairly, it is now time to extend these rights. Fundamental Fairness Doctrine focused on general fairness. The Incorporation Doctrine focuses on specific procedures. So where does this lead us? Well, it leads us, if we look at the next slide, to certain cases that begin to be applied in state courts. So, one of the first cases, Wolf versus California. This is an important case, but essentially it says If is it unreasonable search and seizure, it is a violation of federal law if the state does it as well. Now here's a big one. Matt versus Ohio. If there's an illegal search by a state government, state police force, sheriff, regular city police force, and they find something without having probable cause to conduct a search, it's inadmissible. This is the exclusionary rule. Your right against self-incrimination, this is Malloy versus Hogan in 64. Your right to have assistance of counsel even if you can't afford it, that's Gideon v. Wainwright, 63. Your right to confront witnesses against you, that's Pointer v. Texas. It's your right to subpoena people, compulsory process to obtain witnesses, Washington v. Texas, 64. Your right to a speedy trial, 67. And the right against cruel and unusual punishment, which is a little bit further back, which is cruel and unusual punishment. Now this is as of 2007. There's an interesting thing that we need to talk a little bit about, and this is the, we said, okay, the court was working on fundamental fairness. Then they decided, well, we're going to use the theory of incorporation, right, to give you these rights. Well, the theory of incorporation is running into a bit of a problem today. And you're asking yourselves, well, what is that problem, Professor Chapman? Well, let me tell you, it's strict constructionalism. The current Supreme Court of the United States, the majority, supports something called strict constructionalism, although their preferred term, they prefer the term textualism, that's what Scalia called it, or originalism. Now, some justices are perfectly okay calling it strict constructionalism. Some are not. But strict constructionalism or textualism says the Constitution should be interpreted or applied according to the wording and the understanding of those words or concepts when adopted. That means, what does the Constitution mean? What rights might you have under procedure? You have those rights that were understood when the 14th Amendment was adopted. So the 13th, 14th, and 15th Amendment, these are Civil War amendments. So they're coming in from 1864 to 1868. Okay, so we're looking at 130 years ago, right? No, more than that. 150 years ago. So what did we mean when the 14th Amendment? Did the 14th Amendment, when they drafted it, mean that you had the right to have an attorney appointed for you and have the state pay it? Well, I think the answer there would be no. Because I don't believe, possible exception of some capital cases, that any state in the United States was providing for routine felony arrests an attorney if you couldn't afford one. So here's your problem. The Incorporation Doctrine is clearly in conflict with whichever doctrine you want to call it, strict constructionalist, originalist, or textualism, which is the majority opinion of the Supreme Court. So I think what we should pay attention to here is that it is entirely possible that a lot of these rights that we're talking about here could be rolled back by the Supreme Court. So as an example, and it's a little bit outside of criminal law, is, you can think of Roe v. Wade. Now, forget for a moment whether you support or oppose abortion. I don't want to open up that messy debate. But Roe v. Wade is in many ways established as a fundamental right back in the late 1960s, 1970s, in much the same way that these incorporated rights are granted. Okay, so since 1973, you have a fundamental right in the United States to have abortion. Fast forward to a couple years ago, the Supreme Court of the United States doesn't say abortion is legal. The new decisions on abortion at the federal level doesn't say it. What it does say is the federal government doesn't guarantee you these things, and it pulled back. At that point, the state governments, right, they lose that federal floor. So the state governments can do what they want. So you can easily see if, say, Justice Thomas, who is a strict constructionalist, was to write an opinion about some of these criminal rights, that he could roll back, your right to counsel, your right to speedy trial, your confrontational right. They could say, yeah, you've got all those rights federally if the federal government arrests you, but if the state of North Carolina arrests you, that's their business. It's a fascinating and a very important aspect of this. Is what I'm teaching you now is built upon this theory of incorporation. But don't think that this is eternal, because the Constitution is interpreted and rewritten by every generation. Every generation looks at it, decides what they like, decides what they don't like, and changes it. All right, equal protection of the law. A constitutional command since 1868 grants you equal protection, protects people from being investigated, apprehended, convicted, and punished unreasonably. That is not the same thing as saying that everyone has to be treated alike. But it is saying that any treatment has to be reasonable. Now, equality is a messy and dangerous term to define in a single sentence. If you just say equal means everybody's treated the same. No. It might mean everybody has the same opportunity. It might mean you're not guaranteed the same outcome, but you're guaranteed the same process. So again, let's go back to picking a jury. If you say that everyone is guaranteed equal protection, that you are guaranteed a fair jury, well, what does that mean? If you are a black defendant, does that mean that that jury can't be all white? I would argue that, yeah, that's probably if the whites were placed on the jury at the exclusion of blacks. But how far do you take that? Again, if you are a Buddhist, does that mean that it's wrong to exclude Buddhists from that jury? Or do I have to include Buddhists on that jury? If you're white, does there have to be white people on the jury? If you're black, does there have to be black people on the jury? If you're a woman, does there have to be women on the jury? How many? To what number? The application of equal protection is a messy business and is not as clear-cut and not as easy as you might hope. Okay. Violating equal protection law. If you're going to claim that your equal protection of the law was violated, you've got to prove two things: discriminatory effect and discriminatory purpose. That the official action was based on race or some other group identity, which we accept as being protected. I think that's an asterisk that wasn't put in there. So, let's suppose, let's suppose we've got a right that's not as widely recognized or accepted. Let's suppose you're an atheist. You don't believe in God. And you go to court and you say, look, you're making these people swear on a Bible. That's silly to me. It's discriminatory to say that if someone won't swear on a Bible that they can't testify. Now maybe we've got an affirmation as an alternative. So I'm being discriminated against. Well, we don't recognize that yet. We don't, or if we ever will. And you go back 50 years and you say, well, you're admitting people to judge my case, and I've been arrested for, in North Carolina, the felony crime against nature because I'm gay. And you're putting on people in the jury that believe being gay is wrong. Is that a discriminatory effect? An official action based upon race. Who are you putting on the jury? People that don't like gays. Do we identify whatever group we're talking about or whatever individual we're talking about as it's discriminatory to treat them in a different way? The discriminatory purpose is the named official in the group intended to discriminate against the named individual because of their race or some other group identity. Now, some of these group identities are well established. Obviously, race is. If you can say you created an all-white jury to convict a black man, fine. Or vice versa, all-white jury or all-black jury to convict a white man, fine. Gender is fairly well established. You created a jury composed just of men or just of women. It gets messier and messier as we keep subdividing up whatever group we're talking about. Is religion discriminatory? Well, you have freedom of religion. Yeah, I would say it probably is. Is age discriminatory? Is, political belief discriminatory? Is wealth discriminatory? I mean, you can keep subdividing people up to the point of when is a group identity something we're going to respect and examine. All right, I told you I was going to keep this right at about an hour. I went over by about 5 minutes because a little long-winded today. But whenever you're ready, Chapter 3 will be posted and ready for you. I will do some quick corrections in post-production here. There's a few spelling errors I caught, a few issues, but other than that, have a happy and productive day, and I will see you in class or see you in the next lecture if you're listening online. Chapter 3.